trying to connect the Hong Kong people and the New York people in terms of business and promote the mutual understanding of the two cities. And hopefully we can create more buzz and then create more business opportunities for our members. We are very happy today to have Damien Laracy, who is the head of the Hong Kong branch of Hill Dickinson. He is a business attorney and a maritime attorney, and he's been practicing for some time. Their firm has more than 200 years of history, almost as long as the history of the United States. And so it's a very reputable firm. They have their head office in Liverpool, England, and many branches in the world. They have more than 400 lawyers in the firm, and we are very grateful that they became a corporate member of our organization, and they are taking the time to explain what's going on with a very interesting topic today about counterfeit goods or bad goods that are being sold to the United States. And since it's a very technical subject, and hope he would simplify the process and help us all understand the process. Mr. Laracy has about 30-minute talk, and after that we'll have a Q&A for about 10-15 minutes, and for people to make comments and also ask questions. So please write it down, and then we'll go over them. Without further delay, I'll give the floor to Mr. Damien Laracy for today's talk. Good morning, good evening you there in Hong Kong.
Thank you very much, Raymond. Let me say, first of all, thank you very much to Michelle Moy for handling the logistics and the technology around today's presentation. Thank you also very much to the Hong Kong Association of New York for welcoming Hill Dickinson as a corporate partner. We're very, very proud and very happy to be embarking on this relationship in the year of the ox. And of course, thank you all for attending. I'm a New Zealander. I've been in Hong Kong for 26 years. Some people would say I'm an expatriate. Others would say I'm an immigrant. But any way you look at it, Hong Kong is now my home. And like many immigrants, I find myself increasingly feeling very attached to Hong Kong, very fond of Hong Kong. And part of the presentation that I'm going to give today is unashamedly going to be involving a little bit of cheerleading for Hong Kong, both in terms of the disputes capabilities in Hong Kong, but also in terms of the corporate and transactional capabilities of the legal community. I will just give a couple of caveats and disclaimers. I was not sure today who the audience would be. I'm still not entirely sure. So I'll make it very clear, this is not going to be a law lecture. There are certainly elements of what we'll touch on today that are legal, but anyone who has a legal background, or anyone even involved in importation of medical goods, or even anybody involved in law enforcement or border control, will appreciate that a lot of what I talk about today is capable of a much greater, sort of more granular analysis. But we only have 30 minutes today. So what I'm going to do is just to give you a little bit of context about why you're sitting where you are this morning listening to a New Zealander in Hong Kong talking about Chinese-made masks being imported into the States. As I say, let me give you a little bit of context behind that. As I say, I've been in Hong Kong for 26 years, and regularly throughout that time, I've worked for US law firms, with US law firms, and for US clients and US importers and distributors. And we've been involved in a wide range of issues concerning business in Hong Kong, Macau, and China. Everything from importation and sale of goods disputes, to insurance disputes, to business diversion and fraud disputes, to insolvency and debt recovery. And that remains sort of the general day-to-day body of the work that I do in this office and what my colleagues do. But over the past 12 months, we've also seen a definite definite theme emerging. And we've seen two more strands of work coming through with more regularity. One is internet fraud, and the other type of work that we've been seeing a lot more of concerns complaints about defective personal protective equipment. And that's obviously what leads us into the talk today. I have a client in the States. Obviously, I won't go mentioning the name of the client. They're based on the Eastern Seaboard. They are involved in importation of a wide variety of consumer products, electronics, and also garments, and more recently, personal protective equipment. As part of the exercise that we've been doing with this client, investigating options for recovering but basically wasted purchase prices in Hong Kong against a Hong Kong exporter. As part of that exercise, we were looking at sourcing from the United States some information about my client's quantum of loss. Parts of the quantum of loss analysis are very straightforward, i.e. what were the sale purchase prices, i.e. what were the invoice values. Secondly, what were the invoice sums associated with the air carriage, because of course a lot of this was taking place at very short notice. People were demanding a great deal of urgency, very short lead times, so everything was being carried by air. So those components of the quantum claim are quite easy to work out. What was less easy for us to establish in Hong Kong was what happens to cargo of this type when it lands in the United States, is seized at the border by the Department of Homeland Security working with the Customs and Border Control. What happens then? There are obviously storage charges that start racking up. There can be clearly testing charges, transportation charges, there can be destruction charges, there could be repackaging charges if there's going to be an attempt to try and repackage the goods and then sell them perhaps as 3-ply or surgical masks rather than KN95 masks. So when we were searching around looking for somebody to help us with that analysis, my client introduced me to an accountant in New York. And again, I won't go naming names because I think I have seen their logo on some of the HKANY publicity. So that was an immediate connection with New York. And it was at that point that I thought to myself, I need to reach out, and we as a business in Hong Kong need to try and do what we can to strengthen ties with New York. And that is essentially what we did by then contacting the HKANY. And very quickly and very happily, Michelle and Donald suggested that I take some of your time and give you a recent or a case study and a little bit of a war story about this particular matter that involves importation of personal protective equipment. The litigation in Hong Kong is ongoing. We also have litigation ongoing in China and in Singapore. So some of what I will talk about is indeed in the nature of a case study, but some of it is going to be simply informative and speculative as to how this might unfold, because as I say, the litigation is at a relatively early stage here in Hong Kong. And I've also taken the liberty this morning to throw in a little bit of history, and then, as I say at the end, a little bit of cheerleading in relation to Hong Kong generally as an environment in which to do business. So perhaps there's something for everybody, I'm hoping. Michelle, I wonder if we could jump to slide 2. Thank you very much. So looking at, that's slide 1, I think, Michelle. So as Raymond kindly said in his opening remarks, Dickinson has been around for more than 200 years. We have offices throughout the UK. Those of you that are soccer fans, in New Zealand we call it soccer as well, but my new partners in the UK call it football. Those of you that are soccer fans will see we have a strong presence in places like Liverpool and Manchester. Michelle, could we turn to page 3? As I say, I don't need to read all of this. It is on the internet if anyone has particular interest to know more about our history. One thing that I will mention though is that very early on, Hill Dickinson cultivated an inclusive workplace almost a century ago. And a Miss Edith Burton was one of the first women to qualify as a solicitor in the UK and became a partner with Hill Dickinson in 1927. If we turn the page to page 4, as I said, I thought I would put in context this morning, by way of a brief history lesson, the environment in which I, as a lawyer in Hong Kong, operate. Some of you will know, of course, that prior to 1997, Hong Kong was a British territory, and the basic law, which was a constitutional document that was negotiated and signed in 1984 between Deng Xiaoping and Margaret Thatcher, makes it very clear that after the handover in 1997, the British system of law, the common law, was to survive. And that places me, personally on a daily basis in the environment in which I, as a lawyer, operate in Hong Kong. It is the basic law which provides me as a New Zealand qualified, although I'm also admitted in the UK, but as a common lawyer, it is the basic law that provides me with that platform to give common law advice in Hong Kong. Much of that common law advice is indeed derived from the English common law. I mentioned there that we do have a new Chief Justice in Hong Kong. Andrew Chen was sworn in Hong Kong just on 5 weeks ago. He does hold a master's degree from Harvard. If we could turn the page, Michelle, to page 6. And as I say, just continuing the brief history lesson, because I think rather than talking about litigation in Hong Kong in the abstract, it is helpful to understand that it's not in the abstract. The common law system in Hong Kong is enshrined in the basic law. Now, obviously, the basic law has been in the news a lot recently. I'm hoping to avoid getting into any ideological or political discussions today. And there's been a lot of fiery rhetoric on both sides. So I'm not going to be looking at Article 23 of the basic law or trespassing into the national security law. But when one looks at this particular page, one sees here the eight early articles of the basic law. And the thing that strikes me is just how ambitious this document is. And remember, it does date back to 1984. But if you look at Article 1, it talks about, it makes a territorial point. Hong Kong is an inalienable part of the People's Republic of China. You look at Article 2, it talks about Hong Kong having a high degree of autonomy. And now we're starting, of course, to creep into questions of legal authority and legislation. Article 5 then talks about the socialist system and policies and provides that the system of law in Hong Kong will remain unchanged for 50 years. Now, that obviously is a soundbite that we all hear regularly, but here it is, Article 5 of the basic law. Article 6 goes on to record that private ownership of property is to be protected. And Article law, of course, is the law that provides me as a common lawyer the ability to practice law in Hong Kong in an environment and with a legal architecture that I'm familiar with. And of course, Article 8 says laws previously enforced in Hong Kong, that is the common law, and the rules of equity shall survive the handover of 1997. If we turn the page to page 7, that stipulation in the basic law was then reinforced by virtue of the Hong Kong Reunification Ordinance on the 1st of July 1997, which once again confirmed that all laws previously enforced shall be construed with such modifications. So those laws remain enforced, but of course there is a recognition that the basic law exists alongside in parallel. And then if we turn the page to page 8, that's sort of the history and the macro legal context behind me. We turn to page 8. I'm now moving on to really what I think was the teaser that Michelle circulated to you all, namely the discussion about personal protective equipment. The big cover-up of the 21st century. Quite a nice title, I thought. Obviously, we've all been suffering behind masks of various types, or most of us have at least for some months now. It remains to be seen, as I was saying earlier to Raymond, whether a lot of the stories that we're reading about defective masks being imported, whether it's into the States or whether it's into Europe or elsewhere, it remains to be seen whether or what percentage of those imports were indeed the product of intentional counterfeiting, or what were the product of negligent manufacturing. And again, I recall very clearly this time last year, the frenzy, perhaps a little later than this time last year, the absolute frenzy that was occurring globally with people trying to source masks. And there were a lot of factories in China that overextended themselves, that perhaps went from producing T-shirts to producing masks, perhaps without the right controls and processes in place. And then on top of that, they tried to maximize their output by perhaps being overstretched in terms of production. The other thing I will say at this point too is that this particular matter concerning my client is not a personal injury matter. It is not a product liability matter, because these items never made it past the Department of Homeland Security. So happily, the goods we are talking about today never made it to the US consumer. The goods that we are talking about today are indeed masks of the type that this young lady is wearing on the picture. Now, these are N95. In the United States, we would call them N95 masks. The equivalent Chinese standard is KN95. And there's a lot of literature about some of the nuances and the differences between the two classifications, but essentially they are the same. So when we talk about masks that I'm dealing with today, we're talking about masks of that type. We're not talking about the lighter 3-ply surgical masks. We can turn the page to page 9. I won't dwell on this. This is very LA law, or for those of you that are a bit younger than me, very suits. What we see is some well-dressed lawyers around the table taking their time, no doubt drinking coffee. They've got a lengthy document. It's being signed. I'm going to assume it's being signed by people who know what's in the document and who have proper authority. But in the real world, things don't always work like that. And it was very much the case that things were not working like that in March and April last year. We could turn the page, Michelle. So again, these I stress are not in any way cut and pastes from material that I have from my client or that are alive in my particular matter. But these are the types of exchanges that were taking place, and those of you that may have been involved whether on the legal side or on the sourcing side will be familiar with this. People were communicating in very rapid fashion by email, by WhatsApp, by SMS, at all hours of the day and night, perhaps without necessarily thinking about some of the nuances. Of course, where possible, a contractual supplier was insisting on money up front, so money was changing hands very quickly in order to meet production demands and in order to meet perceived supply demands. And when you look at these bubble conversations, as I say, this is very typical of a large number of these types of conversations that I've been seeing. And this to me is the unique feature of the litigation relating to this particular product at this particular point in history, because there was a lot of money changing hands, and not just with poor quality documentation or poor quality contracts, but with really just SMSs and single line messages, maybe 2-line messages. And you can see here the ambiguity that can creep in here. Masks must be legitimate. The more better looking they are, the more expensive. Obviously, there was some poor grammar being thrown around as well. But there was a lot of very loose language. Yet, nonetheless, money was changing hands and product was being shipped. And if we turn the page to page 11, so against that background, that frantic, frenzied background, what was happening nonetheless was that a very common Hong Kong business model was being implemented, namely foreign importers and distributors, in this case my client being a US-based importer, were contracting with a Hong Kong contractual vendor, and that contractual vendor was indeed contracting behind the scenes with a PRC manufacturer. And we saw from the previous slide that often the Hong Kong vendor may have had a family relationship with the factory in China, or a friendship of some sort, or perhaps a previous business deal. But of course, the US purchaser was looking to de-risk their dealing by dealing with a Hong Kong vendor rather than having a contract in place with a PRC manufacturer. So of course, you see at the bottom there that there is no contract between the US purchaser and the PRC manufacturer. So ultimately, I think we know how this particular story unfolds. Masks were received into the US, but were stopped at the border. The FDA, which incidentally has had an office in Beijing now, I think for over 15 years. The FDA works with the National Institute of Occupational Safety and Health, and the NIOSH standards were adopted by and implemented by the Homeland Security personnel when they were testing imports into the States. So again, forgive me if some of this is probably familiar to a lot of you. So the upshot was that the Department of Homeland Security effectively sealed the border in this particular case against my client's product. So they were stopped at the border, did not make their way to US consumers. Nonetheless, the consequences for my client, and here I should say consequences for the US importer rather than the purchaser, were devastating in terms of financial costs. Obviously, there were defaults to purchasers because product could not be delivered. There's an obvious loss of profit angle there. There were increased costs of sale if, for example, some product could be repackaged eventually and sold with all the correct warnings and disclaimers. There was threat of criminal prosecution. And of course, all of the costs that we discussed earlier, repackaging, destruction, transportation, storage, etc., etc. The other point I make, which is my fourth bullet point there, is that in parallel to claims of the type that I'm talking about now, which is a claim really for damages for breach of specifications in a sale and purchase contract, there's another whole type of claim as well. Given the speed with which money was changing hands, people were not keeping their books and their accounts properly. So my client also has a claim against the Hong Kong contractual vendor because it turns out after the dust had settled that my client had remitted too much money and there had never been a particular consignment allocated to some of the funds that had been remitted. So what we have there is a good old-fashioned debt claim. So a claim for return of funds, proprietary funds, we say, namely our money that happens to be in the contractual vendor's account in Hong Kong due to an overpayment. That's a very different type of claim, of course, for a claim for damages, which arises when goods have been shipped but are not up to the correct specification. So I raise that really just by way of a sideline issue. Turning the page to page 13, who are the targets for recovery? Again, the obvious targets are the Chinese manufacturer or the Hong Kong vendor. The problem with going direct against the Chinese manufacturer, of course, is that my client doesn't have a contract with the Chinese manufacturer, and indeed that's the way that the deal was intentionally structured, if you can call an exchange of one-tax structure in the deal. Other potential targets would be an insurer. If there was for example, a business disruption insurance policy in place, various any number of other types of insurance might respond in this particular case. If in normal circumstances where the parties had been engaging in testing and product audits and, for example, factory and warehouse testing and auditing by an organization such as SGS, you might look at suing SGS or whoever was responsible for auditing the product as it left the factory. That was not the case in this particular instance and in many others because the wheels were all turning so quickly. We turn the page to page 14. There are also questions about forum and governing law. Again, I've listed four options there. The PRC is the least attractive of those governing law of those forums. And again, that is why Hong Kong remains such a popular mechanism, contractual mechanism for for sourcing goods from the PRC. If we turn the page, I see the clock ticking against me here. And now we'll get into a little bit of the law, I suppose. Some law at last. So looking at forum, and again, from the previous slides, we've seen that there are a number of potential forums available, some more attractive than others. First question, and I'm sure this is the case in the US as well, I'll speculate that it is. The first thing you look to do is you look to see, is there an express term? Is there an express term in the WhatsApp messages saying, by the way, any dispute between us is to be litigated in Hong Kong or arbitrated in Hong Kong or litigated in New York? Now, of course, you've seen the bubble conversations that were taking place. No one turned their mind to those types of mechanisms. So there was no express term in our case and in many others. What one then does is one looks at the Spiliada test, as we know it. It's an English test, which is also relevant in Hong Kong. And you look at, is there another forum apart from Hong Kong that is clearly and distinctly more appropriate? And you look at a variety of factors. You could look at, for example, a governing law clause, if there was one. In the instance that we're talking about at the moment, there is not. You would look at the place of the business of the parties. Now, that is a matter that counts in favour of Hong Kong because our contractual defendant is in Hong Kong. You might look at where location of witnesses. Now, that is a factor that conceivably could count in favour of the United States, where perhaps Department of Homeland Security witnesses could testify as to the quality of the product, and perhaps NIOSH could also testify as to the quality of the product. So you have to weigh up these various factors in the absence of a specific forum clause. And you then look also at to what extent would the plaintiff, namely my client, be deprived of any legitimate advantage if the trial was, if he was forced to litigate outside of Hong Kong. And we would say that there would be a deprivation for our client who was forced to litigate outside of Hong Kong because our defendant is in Hong Kong. So the natural consequence of that would be that if we sued in the United States, we would then have to serve those US proceedings outside of the United States on the defendant in Hong Kong. So that becomes procedurally much more fiddly. And then, of course, as is often the case, there's a balancing exercise, which the courts will undertake in circumstances where Hong Kong is challenged as a forum. In this particular case, Hong Kong has not been challenged as a forum, and it may well be that our defendant in Hong Kong recognises that there is at least some certainty in defending himself in Hong Kong. If we turn to page 16, Michelle. Quite aside from forum, there's also a procedural issue that needs to be addressed at the outset in relation to governing law. And people often bundle these two together, forum and governing law, but they need not be the same. You can frequently have a situation in Hong Kong where you'll be suing a Hong Kong entity in Hong Kong, but the law of the relevant contract could be Australian law, it could be US law, it could be Thai law. So the law of the governing contract does need to be isolated and analysed separately. Once again, though, you look first of all to see if there's an express term. In the absence of an express term, the case law, and again, this is Hong Kong case law, but based on English law principles. You look at a range of factors. You look at, for example, the place of intended performance. Now, arguably, the intended performance in our case was the United States. That is where the goods were meant to be delivered in good condition on specification. You also look at the domicile or residence of the parties. Of course, our defendant is in Hong Kong. And then if we turn the page, as I said before, I'm happy to say that in our particular case, as you see from slide 17, there has been no challenge raised, fingers crossed, to Hong Kong as the appropriate forum, and nor has there been a challenge raised to Hong Kong law being the relevant governing law. If you look at page 18, there's an almost superficial summary that I've provided there of how this might unfold going forward. And as I say, we're at a relatively early stage in Hong Kong. If you look at the oval bubble on the left, if we obtain a judgment in our favour, the question will then be, will the judgment debt be settled? If yes, obviously that's happy days for everybody. If no, then what we will do is we'll wind up the Hong Kong contracting vendor, and we will appoint a liquidator in Hong Kong. And this is where the analysis and the law can get very complex. And we will fund that liquidator in Hong Kong in order to commence legal proceedings in China, or perhaps even in Hong Kong, against the factory. So, as I say, if the contractual counterparty, Hong Kong vendor, does not honour the obligation under the judgment debt, we will wind that company up, we will appoint a liquidator, and we will fund that liquidator to then chase the factory either in Hong Kong or in China. Looking ahead to pages 19 through to 22, I've identified here some arrangements that are increasingly common between Hong Kong and the mainland China, and which will indeed provide us with some ability to enforce judgments between Hong Kong and China, and to enforce arbitration awards between Hong Kong and China. And again, as I say, with my particular matter at the moment, we're not yet at a point in Hong Kong where we have a judgment. But in due course, it may well be that we look to invoke one of these arrangements. And you see, for example, at page 21, I've given a table there summarizing some of the integration that has taken place in Hong Kong over recent years, and indeed in the mainland China, to allow closer and better cooperation between authorities in Hong Kong and in the mainland China, so as to allow better enforcement of Hong Kong judgments and also better enforcement of Hong Kong arbitration. One of my personal favorite slides is the slide at page 22. And I say this out of a great deal of self-interest, because there was an arrangement that came into place in 2019, which is the arbitration interim measures arrangement that I'm referring to here, which allows a Hong Kong claimant in an arbitration to ask a PRC court to freeze assets or freeze funds in the PRC, even though the Hong Kong arbitration is at a very early stage. So if you look at the timeline at the bottom of that slide, we commenced proceedings in Hong Kong in October 2019. On the 1st of October, on the 2nd of October, we made an application to the Hong Kong International Arbitration Centre, asking for a letter certifying our entitlement to ask the PRC authorities to freeze assets. And we then indeed did freeze assets with the assistance of the Shanghai Maritime Court on the 8th of October. So in the space of 1 week, without any judgment, without any arbitration award whatsoever, we had invoked the interim measures arrangement to secure our client's claim by way of freezing funds in a bank account in Shanghai. So that's a wonderful tool for us to have access to in Hong Kong. We were the very first firm, I should say, that ever implemented that. I think it came into force at the end of September, and we started the machinery rolling, as I say, on the 2nd of October for the very first application. I then mentioned very briefly on the next page some of the other developments about to take place in relation to enforcement of arbitration awards. There's a 2020 supplemental arrangement that's coming into force very shortly. It's not yet enforced. There's actually a typo there. If anyone is looking at this screen at the top there, it should read refines the existing 2000 arrangement. So there was an arrangement that came into force in 2000 to allow greater recognition and enforceability of Hong Kong arbitration awards as between the mainland and Hong Kong, and that is now being enhanced and improved. So it has even more teeth as soon as this 2020 supplemental arrangement comes into force, we think sometime this year. I've mentioned arbitration at the end there, really by way of completeness, because as I started off saying, the matter that I'm involved with in Hong Kong for my US importer client is a litigation matter. We're proceeding through the courts in Hong Kong, but there's no reason at all why, in broadly similar circumstances, the parties could not have agreed to have a Hong Kong arbitration clause. So as I say, I've very briefly touched on, perhaps superficially, some of the recent arbitration developments at the end of those slides there. I'm conscious that I'm very close to running out of time, so what I'll do is I'll move to slide 25. And this is the portion of my presentation that Donald Moore encouraged me to include. He said I must have a portion on general cheerleading for Hong Kong, quite aside from disputes and arbitration and litigation. And as I say, I'm a very proud Hong Konger these days, so this is by no means a hardship. But when you look at these slides, there are any number of reasons to do business in Hong Kong, and to have your disputes resolved in Hong Kong. Hong Kong has the largest pool of RMB liquidity outside the mainland China, so there's obviously a finance and a trade imperative. We do have, despite what has been said in the press, we do have a very robust legal system. There's no sense in which that has been undermined in any way by the events of the last 12 months. Article 85 of our basic law says that Hong Kong courts shall exercise judicial power independently and free from any interference. Article 84 of the basic law states that judges and judicial officers shall adjudicate cases in accordance with the law. So yes, Hong Kong has had some growing pains in the past year, but it remains a first-class jurisdiction and a very safe jurisdiction in which to do business. There are always going to be and still are very good tax reasons for doing business in Hong Kong. The highest corporate tax rate is 15%. The highest personal tax rate is 17%. If we turn the page to page 26, Michelle. There are great geographical and connectivity reasons for being based in Hong Kong or for having the centre of gravity of your business in Hong Kong. We have the high-speed rail network connecting us with the Greater Bay Area. There's an enormous amount of excitement about the Greater Bay Area. There will be more integration and movement of labour, resources, recognition of qualifications between Hong Kong and the Greater Bay Area. I mentioned at the bottom of slide 26 that Hong Kong remains, I think, top of the table still for capital raising and IPO purposes. I mentioned on slide 27 that Hong Kong is a signatory to the New York Convention. So those of you that are familiar with arbitration or have arbitration clauses in your contract, you will find that the New York Convention does allow you to enforce arbitration awards made, for example, in the United States. You'll be able to enforce those in Hong Kong, and you can also enforce those in China. That really concludes my presentation. I am conscious that I perhaps rushed the last portion of that, dealing with the non-litigation, non-arbitration portion. But as I said at the outset, I'm very happy to come back at some later stage and do a deeper dive into perhaps some more of the detail of any of the law or any other aspect of it. So thank you very much.
Thank you very much, Damien. It was very informative, especially for our members who had disputes in China. As a fellow attorney, I always have trouble collecting. I think the clients are always worried about, hey, if I get a judgment, am I going to get collected? And what is your point of view, say if you get a judgment in Hong Kong and try to collect, because the local authority has so much power. I have recent similar case as yours, and the PPE situation, they went to the police, they went to the court, they went to the politicians, and they were going nowhere. They say, you know what, I have to hire a US attorney and file in federal court and let the world know about this, and then give them pressure. Now, so how would you advise people to try to get paid in China when local government is so powerful?
I think the first part, the first part of the process is always to be very careful with your counterparty risk. Obviously, you need to do due diligence about who it is that you're dealing with. Do they have assets? When disputes arise, I think another important thing to do is to try and involve the local courts as much as possible. So I have seen situations where, for example, a settlement agreement has been entered into. So let's say you do commence proceedings in China and you perhaps obtain a judgment in China. And we can come back a little bit later as to whether or how often that in fact happens. But if you're fortunate enough to obtain a judgment in China, try and keep the local authorities or the local court involved in the collection process. So you want the payments to be made into the court, for example. Have the court authorities monitoring the settlement terms and the installment payments. So there's one trick, and that is something that I have seen deployed very effectively in circumstances where people have reached a settlement with a Chinese counterparty, or indeed there's been a court judgment imposed. As to how you get to a point where you obtain a judgment or you can assert leverage on the other side, it is very difficult. I think it's hugely important to have local knowledge on the ground in China, and I don't mean just Chinese lawyers, I mean Chinese lawyers in the particular city in which your target is based. Obviously, China is a very large place, and a lawyer in Shanghai is not necessarily the right lawyer to be handling a claim against a counterparty in Dongguan or in Guangzhou generally.
Now, your topic is very technical. We don't see too many people asking questions, but it would be a good opportunity for me to ask you a lot of questions. We have cases that came to the United States because both the plaintiff and defendant did not want to entertain their issues, their disputes in China, and that including state-owned enterprise. Why? Because what they did probably was not very legal, so they don't want to have the disclosure. I don't know if you have cases like that, that parties went to Hong Kong to resolve their disputes.
Yes, regularly we do. And often it will be, for example, with if there's an arbitration clause in the contract, obviously that's a separately negotiated provision within the sale and purchase contract, and that can be very heavily negotiated. And if you're a US importer and you're dealing with a Hong Kong exporter, and they provide you with their terms of trade, you do not need to accept sort of blindly that litigation should take place in Hong Kong or arbitration should take place in Hong Kong. You can indeed negotiate for litigation in the United States, of course. Now, the Hong Kong exporter will probably push back. But in the same way, if you're dealing with a Chinese counterparty direct, so if you are dealing direct with the factory, their default setting will, of course, be to insist or try and insist on PRC litigation or PRC arbitration. But there's absolutely no reason, once again, why you can't look at their terms of trade and say, sorry, that's not acceptable to us. We would be more comfortable with a Hong Kong dispute resolution clause or a Hong Kong arbitration clause. So we regularly see Chinese parties being invited and encouraged and occasionally forced to agree to offshore dispute resolution clauses.
Now, we see a lot of clients from China or in the United States try to make money quickly during this pandemic and try to buy these PPE, like through the internet and through the Hong Kong shell companies. And now they borrow money and then wire money over, and then they don't see the PPE.
Yes.
And they have no money to go forward and hire a lawyer. Now, what do you advise them to do?
That is a very difficult question, and we have a very different system here from what you do in the United States. So we are not permitted in Hong Kong to act on a contingency fee basis. So once legal proceedings have been commenced, we must act on an hourly fee basis. Now we can be flexible. We can talk about capped fees. We can talk about discounted fees, etc. But the American style notion of taking 20 or 30% of the winnings, i.e. a contingency fee arrangement, is in fact unlawful in Hong Kong. It's a criminal offence, and there's a lot of criticism of that, including that it's very old-fashioned, and it's coming under a lot of pressure, and that particular rule will change. Whether it's this year, next year, or in the next 5 years, I'm not sure. But to answer your question, that does leave us nonetheless with a couple of tactics. If we're dealing with a corporate entity in Hong Kong, we would issue what's known as a statutory demand. So that's something prior to commencing court proceedings. So we would send a letter during 21 days under the section 177 of our company's ordinance to pay the undisputed debt. If they don't pay the undisputed debt, we would be free to wind up that company. And that will often get the attention of the board of directors in a way that sort of a standard letter of demand will not. If that doesn't get their attention, what we can do is we can prepare court proceedings, and we prepare what's known as a writ. I think you would call it a complaint, and we would attach to that our statement of claim, and we can send that across to the company and say, if you don't respond within 7 days, this is indeed what we would be filing at court. And quite often that will create a positive response, because they'll obviously see that you're serious and you've prepared your legal proceedings. And at that, so both of those steps we can assist with on a conventional contingency fee basis in the right circumstances. You know, if the facts are right and the client's got the correct paper trail, that would give me the confidence to either proceed with a statutory demand or to proceed with preparing a writ to get the attention of the company. Once we file that writ, though, unfortunately, we can no longer work on those very flexible American-style contingency fee arrangements. So, as I say, you have to divide the exercise very clearly into pre-issue of the writ and then issue of the writ onwards.
Do you work with a Chinese lawyer in China that take up cases like that on a contingency basis?
I know of one firm in China that is doing exactly that at the moment. Now, this is not in relation to a PEP matter. This is in relation to an internet fraud matter. Very, very sad story, in fact, concerning an elderly gentleman from San Francisco. So again, Chinese lawyers are very sophisticated these days. A lot of them, of course, would prefer to be charging hourly rates rather than contingency fees. But there are Chinese lawyers that will indeed get involved on that basis, and they are permitted to. And they do not have the same restrictions that we have in Hong Kong about contingency fee arrangements.
As you can see that from your work, there are more and more fraud cases involved. What we see here in the United States is securities fraud. Right. That a lot of these Chinese investment advisors setting up Chinese companies and told their investor that they will invest in the United States with the New York Stock Exchange, with the etc. Do you see financial fraud like that being done in Hong Kong? Because Hong Kong Stock Exchange use Chinese accounting rules, and which in the United States we're trying to eliminate them. So you see that would be a big part of the work in the future?
We haven't seen a whole lot of that. We've seen bits and pieces of it. Obviously, Ant was in the news recently. Luckin Coffee was in the news, obviously, all over the world. We don't see a lot of that here at the moment, but I think you're right. As with internet fraud, there's every reason to expect that we will need to be, there will be more of that coming down the pipe as well, especially as the tide goes out. We haven't yet seen what the world looks like after all the quantitative easing relaxes, and I think there will be a lot of businesses that will be in a very bad way once this pandemic eases. And that, of course, is when we will see what the state of their books and the state of their accounts is really like.
Now, your firm is a kind of a mega firm with 400 lawyers. I'm sure it may come across with some intellectual property work. Here in the United States, that our government is, with the US-China relationship being the way it is, and many Chinese nationals in the United States who are working in high-tech area are facing criminal charges, or professors in universities. Mm. In Hong Kong, being a major firm, do you see IP litigation in the level like the United States, or become a problem?
We don't see IP litigation in the same way that you see it in the States. As I understand it, a lot of your IP litigation is driven by the fact, or at least traditionally, that you had jury trials. So there are some very large awards coming, sort of David versus Goliath type scenarios, very large awards, and very large contingency fees. As I say, we don't have that fee incentive in Hong Kong. There is definitely IP litigation that takes place, but there's not as much of it as I'm aware that you have in the US.
Now, aside from these like counterfeit goods that you are dealing with, we have many members in the United States that wanted to know what can your firm help with other than this area? Anything that is hot in Hong Kong that you can be of service to them?
I think we can very much be of service in introducing people to lawyers in China. So we have very good connections throughout China, both for disputes work and for also corporate and commercial work. So we can make introductions. We can also project manage from Hong Kong any negotiations or work that is given to PRC lawyers. We can also, I think we're very well positioned, and we do a lot of this, to convert foreign arbitration awards or judgments into Hong Kong awards, and then talk to clients about enforcement options in China. You know, we're all familiar with some of the sad stories that involve parties with claims against Chinese parties. There are also some very good stories, some very encouraging stories. I have been involved in securing, as I mentioned earlier, in securing funds in China, freezing funds in a way that we're familiar with by way of injunction. I have been involved with converting a Hong Kong arbitration award into a PRC award and then enforcing that. So, but again, that whole landscape has got much more nuanced and complicated recently with the very welcome arrival of these new arrangements. So we can give guidance around that. And then in terms of domestic work in Hong Kong, in terms of debt recovery and insolvency, employment disputes, fraud, business diversion, we're very well placed to assist with that. As I say, I've been here 26 years. I have 22 colleagues doing disputes work here.
Damien, we have a question by
Sure.
Douglas has Invest Hong Kong has a question. Since I mentioned about financial took place in what I was mentioned, you know, about financial fraud. Is there a role for the bank to play?
I think in terms of doing greater client due diligence, perhaps yes.
I think the problem is that most people don't do due diligence. I mean, like especially Chinese investors, like small player, not the financial institution, like this mom and pop just try to, you know, borrow money and try to buy PPE and try to make money quickly without knowing the ins and outs of business transaction, and they don't consult with lawyers, and they come to you only after things happen.
Yes, no, that's right. Yeah.
Damien, I think our time is up. We thank you very much for your time, being a new corporate member, and be so kind to spend the time to give a seminar to us and learn about your work. So now we have an extra firm and another friend in Hong Kong where we can reach out to. And thank you very much for your firm's support.
Thank you very much, and Kung Hei Fat Choi to everybody.
Right, and I am concluding the today's seminar, and since this is our first seminar, Year of the Ox, Kung Hei Fat Choi, Gong Si Fa Cai, everybody get rich, and here we conclude our program, and hopefully next time Donald can come back and become a moderator. Thank you very much.
Thank you very much, Raymond. Thank you, everybody.
Thank you. Nice working with you.
Thank you very much.